Hello, my name is Hannah Budd and I am a partner at the International Family Law Group LLP. The International Family Law Group is a specialist family law practice based in Covent Garden, London, looking after the interests of international families and their children. My work has a particular emphasis on resolving complex family law cases, often with an international element, including disputes in relation to the jurisdiction and the resolution of complex financial issues. I'm going to talk to you today about the ability of the English courts to make an order for financial provision after a foreign divorce under Part 3 of the Matrimonial and Family Proceedings Act 1984. It is quite an unusual piece of legislation and very few other countries in the world have equivalents. I'm going to tell you firstly about the background to the legislation and a little of the history of its use. Secondly, the jurisdictional criteria that you must satisfy in order to bring an application. I'm going to talk to you about the process and the types of award the court can make. Then talk you through the leading Supreme Court case of Agbaje and other uses of Part 3. In terms of the background to the legislation, in the 1970s and early 80s, as the amount of international travel increased, the English family law courts were placed in a difficult situation. If they recognised a foreign divorce, as was public policy to do so as much as possible, they effectively closed the door altogether to any further opportunity for the English courts to grant financial provision to deserving spouses. 3 decades ago, the financial provision, primarily for women on divorce, in a good number of countries was derisory and much worse than the position is today. Hence, there was substantial forum shopping at those times and much litigation to show that certain foreign divorces, often Islamic divorces, were not entitled to be recognised as divorce. Much of the case law on the recognition of foreign marriages and divorces derives from this period for this very reason. If the divorce abroad was recognised, it was the end of the opportunity for the English courts to grant financial provision on the end of a marriage. It was all unpleasant, costly and often unjust. It rarely produced a fair outcome. Part 3 of the Matrimonial and Family Proceedings Act 1984 was introduced to overcome this problem. In essence, if there is jurisdiction for divorce in England and Wales, or an interest in a matrimonial home here, and there has been a foreign divorce, the English courts have discretion to grant financial provision. The legislation sets out the circumstances in which the discretion might be exercised. The applicant must have taken a good part in the foreign proceedings, used the local remedies available to them, and done their best to seek reasonable financial provision where the divorce had taken place. The court could then, in effect, make the same orders here in England as if the divorce had taken place here in the first instance. It has the power to obtain financial disclosure. Initially, after the legislation was passed, there were a number of successful cases over the next decade. However, the international family law globe was changing. Lawyers were frequently travelling from one jurisdiction to another and sharing developments in family law. Rights for women on divorce increased in many places. There was much greater international family law comity, including between judges. The English family law courts grew nervous and felt awkward about exercising this jurisdiction, in effect acting as a court of appeal upon the decisions of the courts in other countries. It became an unattractive feature in applications before the English courts from divorces of other Western jurisdictions. In the case of Holmes in 1989, Lord Justice Russell said that prima facie the order of the foreign court should prevail, save in exceptional circumstances. For the next 15 years or so, it was a rather underused jurisdiction. Certainly it was useful where the jurisdiction had been in a country in which, to all intents and purposes, one party, invariably the wife, had negligible rights and entitlements on divorce. However, even then, the English courts trod warily. However, in the past 8 years or so, the English courts have started again to use this legislation more frequently and more assertively with third world jurisdictions, westernised jurisdictions, and now even within Europe in narrow circumstances. Following the 2010 case of the Supreme Court in the case of Agbarje, Part 3 has gone from being a most underused remedy to again being an opportunity for fairness and justice for some international families. It is enjoying somewhat of a revival. In order to bring an application under Part 3, there must have been a divorce, an annulment, a judicial separation which has taken place abroad. That divorce, annulment or judicial separation must be recognised in England. Thereafter, the applicant must satisfy the jurisdictional criteria. There are 3 primary bases for jurisdiction if a party seeks to make an application under Part 3. Namely, 1. The party must either be domiciled in England and Wales at the time of the foreign divorce or at the time of the application, or either party must have been habitually resident for 12 months in England and Wales at the time of the foreign divorce or at the time of the application, or one party must have an interest in the possession of a dwelling house in England or Wales which had been a matrimonial home. They needn't have lived in it at the time of the divorce. In the third instance, the powers of the court will be limited to the interest in that property. It does not have to have been the primary matrimonial home. It is also not necessary for either party to own the property as long as they have had a beneficial interest in the possession of it, which will therefore cover many trust interests. You should be aware that post 18th of June 2011, the above jurisdictional bases only apply if the application does not relate to a case where the jurisdiction is determined by the EU maintenance regulation. Following the introduction of the maintenance regulation, there is an amended additional section 15(1)(a) to the effect that if there is an application or part relates to a matter where jurisdiction is to be determined under the maintenance regulation, for example if it is maintenance from another EU member state, then those maintenance regulation jurisdictional requirements are to determine whether the English court has jurisdiction to entertain the application and not section 15(1). The effect is that it will make it very difficult to successfully claim under Part 3 following maintenance in the EU. I'm now going to talk to you about the process. A Part 3 application cannot be made unless leave of the court has been obtained. This is invariably obtained without notice to the other party. Generally speaking, the court will not grant leave unless it considers that there is a substantial ground for the making of an application for such an order. The Part 3 process follows a similar form to financial applications made following an English divorce. The parties will be ordered to produce financial disclosure, and ultimately, if the case does not settle in negotiations, the level of the award will be determined by a judge. At the final hearing, the judge has the ability to make the same orders that it can make pursuant to an English divorce. These may include orders for the sale and transfer of property, payments of lump sums, pension sharing orders, and ongoing spousal maintenance. However, where a case is brought on the jurisdictional basis that the parties have an interest in a dwelling house in England or Wales, the court's powers will then be limited to the interest in that property. The leading authority in England on Part 3 applications is the case of Agbarje. In terms of the background, the parties were married for 38 years. They were both Nigerian by birth, although they had met in England in the 1960s and acquired UK citizenship in 1972. All 5 of their children were born in England, and all but one was educated here. In 1975, the husband bought a property in London in which the children stayed with their nanny. For the majority of their married life, the couple lived in Nigeria. They separated in 1999, at which point the wife came to live in the London home, where she remained ever since. In 2003, the husband issued divorce proceedings in the Nigerian courts, in which the wife sought financial relief. It was recorded that she played a full part in the Nigerian proceedings. The Nigerian court gave her a life interest in a property in Lagos with a capital value of around £86,000. and a lump sum which was equivalent to £21,000. This totalled £107,000. The total assets were approximately £700,000, of which £530,000 was represented by the 2 properties the couple owned in London. The wife received 15% of the overall assets. I take this opportunity to remind you, of course, that it was a 38-year marriage. On an English basis, the Nigerian court order was thoroughly unfair. It gave her no accommodation in England, and the wife would face homelessness. The Nigerian settlement had not taken into account the couple's English properties, and they had no ability to make orders in relation to them. The wife duly applied for relief under Part 3 of the Matrimonial and Family Proceedings Act. In the High Court in London, she received 65% of the proceeds of sale of the London property to enable her to house and maintain herself in London, which was about 39% of the overall assets. A relatively significant departure still from equality, but nevertheless it provided reasonably for her needs. The High Court was anxious that the wife was simply seeking a second bite of the cherry, and asked what were the exceptional circumstances that Holmes had referred to previously. In order to allow such an application to proceed when proceedings in another country had been conducted appropriately and led to a financial order in the wife's favour which had been implemented, the High Court judge in this case found that it was an exceptional case. He clearly had it in mind that the award for the wife was much lower than it might have been in this country. The husband subsequently appealed to the Court of Appeal, which refused to provide the wife any relief whatsoever. The Court of Appeal relied on the fact that the High Court judge had given insufficient weight to the strong connections that the family had with Nigeria, in finding that the circumstances were sufficiently exceptional to warrant the application. They concluded that it wouldn't be appropriate to grant the wife even another nibble at the cherry. On any basis, it was a harsh outcome for the wife, and she appealed to the Supreme Court. In terms of the Supreme Court decision, when deciding the case, the Supreme Court went back to the original Law Commission recommendations, which were the foundations of the legislation in the early 1980s. The Supreme Court said that the purpose of Part 3 was the alleviation of adverse consequences of no or no adequate financial provision being made by a foreign court in a situation where there were substantial connections with England. There were 2 interrelated duties of the court before making an order. The first was to consider whether England and Wales was the appropriate venue, and the second was to consider whether an order should be made. The duties were interrelated. The following are some of the factors that the court should consider when deciding whether a financial order should be made. They should consider whether it's appropriate in all of the circumstances of the case. They should look to the parties' connection with England and Wales. They should also consider the parties' connection with the country which granted the foreign divorce, annulment or legal separation, and indeed the parties' connection with any other country. They must look at any financial benefit that the party or any child has received or is likely to receive in consequence of the foreign divorce, for example by virtue of any agreement or operation of any foreign law. They must look at the financial provision being given by the foreign divorce, including the financial orders and the extent to which those orders have been complied with or are likely to be complied with. They must look at any right which the applicant has or had to seek financial provision in any country abroad from the other spouse and any reason for the omission to seek that relief. They must also look at the availability of any property in England and Wales against which an order under Part 3 could be made. They should look at the extent to which any Part 3 order would be enforceable. They should also consider the length of time since the foreign divorce. The first consideration must be given to the welfare of any minor child of the family who has not yet obtained their majority. The Supreme Court considered the general principles to the provision. They said that the following 3 principles should be applied. The first and primary consideration must be given to the welfare of any children of the marriage. This can cut both ways, as children may be being supported by the foreign spouse. The second is that the court considered that it may never be appropriate to make an order which gives the claimant more in England than he or she would have been entitled to had all of the divorce proceedings taken place here. The third principle was that where the order should result is that provision is made for the reasonable needs of each spouse. Subject to these three principles, the court has a broad discretion. So the question is, in terms of the quantification, whether the English courts will make an order as if it had been on divorce, or whether it is merely a top-up to the previous foreign order that's been made. Having stated these three general principles, the Supreme Court went on to give guidance on quantification. It stressed that there was a flexible approach and there should be broad discretion. The reasons why it was appropriate for an order to be made were among the circumstances to be taken into account in deciding what the order should be. The full sharing, needs and compensation themes in English family law would be applied. Where the connections of the case to England are very strong, there may be no reason why the application shouldn't be treated as if the divorce had been purely in English proceedings. The Supreme Court also said that there will be other cases where the connection with England is not as strong and a spouse has received adequate provision from the foreign court. It will not be appropriate for Part 3 to be used simply as a tool to top up that provision which they would have received on an English divorce. The reference to needs, one of the three general principles which is set out above, and the reference to the strength of connection with England means that the Supreme Court contemplates that there might be cases where the connection is not strong, whereupon the court will make only a needs-based order rather than what might otherwise be made in terms of a sharing order on divorce if the connection was very strong. The Supreme Court emphasised the flexibility of the approach, and it was at pains to emphasise that it's not simply a second bite of the cherry. It referred many times back to the legislative criteria of no or no adequate provision from a foreign divorce settlement. In referring to the strength of connection with England, invoking a full divorce outcome, such as sharing, there must be the category of assets where the connection is not so strong, but clearly the provision abroad has not been adequate. In these circumstances, it is suggested that the needs principle is more likely to be invoked as the criteria for the outcome. For these applicants, faced otherwise with inadequate provision from the foreign divorce order, even a needs-based outcome will be an oasis of justice in their particular desert. The strength of this connection test has been developed in subsequent case law. I'll now go on to talk to you very briefly about two other practical uses of Part 3, of which I think you should be aware. There are quite a few countries where local family law does not allow orders to be made in respect of offshore foreign property, and this was an example in the Agbaje case. They can certainly deal with real property in the country where the divorce is occurring. They'll not, however, deal with real property abroad, either because the local law does not allow it or because the court will not make such orders. This is surprisingly prevalent in other countries. Part 3 could well be used to overcome the difficulties with this, and it may be used in respect of the English assets in those circumstances. The court looking at Part 3 remedies will always take into account what provision has already been made by the courts of the country where the divorce occurred, and therefore take into account in deciding what is appropriate regarding the English-based assets. The second other use for Part 3 is in relation to pension sharing orders. English pension companies will almost only ever make pension sharing orders following an English court's pension sharing order. Some pension companies abroad are more relaxed and will accept a foreign order or certain form of marital agreement. There are many families divorcing abroad, within the EU and worldwide, where one of the parties has an English pension. The Foreign Divorce Court will have no power to make an order effectively against the English pension because the English pension company will not implement that. In practice, agreement is often reached between the parties and their foreign lawyers that an application will be made, in effect jointly, for an English pension sharing order to be made pursuant to Part 3, in order to give the effect to the settlement which has been made abroad. In those circumstances, English lawyers should always be consulted in advance of by foreign lawyers before an agreement is made final, in order to make sure that the appropriate wording is incorporated into the foreign settlement. I hope that this has given you some insight into Part 3, and thank you very much for listening.